Hello, everybody. This is Tad Schotten, and the case I chose for this week's case study was Vanderbilt versus DiNardo. So this case is about a breach of contract that is brought by Vanderbilt University against their head football coach Gary DiNardo for breaching a contract that he signed. So this case took place in 1999 in the Sixth Circuit Court. Vanderbilt is asking that Coach DiNardo pay damages for resigning to go coach at LSU before his contract was up, stating that he breached his contract. The facts of these cases are that DiNardo signed a 5-year contract to serve as the head football coach at the university from 1991 to 1994. Vanderbilt made it known to Coach DiNardo that they were looking for a long-term coach, to help their program succeed. So the contract was signed on December 3rd, 1990. The contract stated the university hereby agrees to hire Mr. DiNardo for a period of 5 years from the date hereof, with Mr. DiNardo's assurance that he will serve the entirety of his contract. A long-term commitment by DiNardo being important to the university's desire for a stable intercollegiate football program. In the contract, it also stated that it contained reciprocal liquidated damage provisions. This meant and stated that Vanderbilt agreed to pay DiNardo if they asked him to resign, or they found another football coach, or fired him before the contract ended, that they would pay him the remainder of his contract out. And then the same goes for Coach DiNardo. If Coach DiNardo decided to go elsewhere or resign before his contract was up, then he would have to pay that money back to the university. And that part of the contract was found in Section 8. So what happened was the athletic director was Paul Houlihan, and him and Coach DiNardo met in the 1994 season to discuss a contract extension. Coach DiNardo did coach that season, but the university wanted him to sign a 2-year contract extension after that. Well, this is where it gets messy. When the athletic director met with Coach DiNardo, it wasn't done in a professional setting. He met him in his car in the parking lot by the practice facility to discuss this 2-year contract extension. And the entire contract wasn't there, just a certain portion of it was, which is not professional and the right way to go about it. And Mr. DiNardo stated that he, wasn't really sure what he was signing, and that he wanted to see the entire contract and have his brother, which was his attorney, to look it over before it come finalized. The athletic director, Mr. Houlihan, told him that the contract is exactly the same as the one he signed before. It's just adding a 2-year extension. And so Coach DiNardo ended up signing it, the paper that he was given, but he still wanted his brother, his lawyer, to look at it and finalize it. So what happened shortly after signing that extension, LSU called and offered Coach DiNardo their head football coaching position, which he accepted. Vanderbilt was not happy about that, and they believed that Coach DiNardo breached his contract, and therefore he should have to pay those 3 years that he was going to miss not coaching Vanderbilt. So this went to the Circuit District Court, and the court entered a ruling, and they entered a judgment for Vanderbilt against DiNardo in the amount of $281,886. Then DiNardo, he ended up appealing that decision, and he argued that the district court erred in concluding on the following things. He believed they erred on the contract provision was an enforceable liquidated damage provision and not an unlawful penalty under Tennessee law. 2, that Vanderbilt did not waive its right to liquidated damages. 3, that admin to the contract was enforceable, and the addendum applied to the damage provision of the original contract. So those are the things that he was arguing against. Again, DiNardo told Mr. Houlihan that he wanted a contract extension, but wanted to discuss the extension with his attorney. So it sounds like just neither of them were on the same page. In the end, in the appeals court, said it was unclear whether DiNardo's attorney had to approve the 2-year contract extension before it became enforceable, and whether his attorney approved his contract extension and sent it back to the district court. The appeals court threw out the ruling of the district court that DiNardo had to pay the university damages at the $281,886 for quitting to become the coach at LSU. So in 1999, the case dragged on, and they are trying to reach a settlement, a number to agree on. Vanderbilt rejected DiNardo's offer to pay the school $91,781 to settle for after the U.S. Circuit Court of Appeals sided with Vanderbilt in finding that DiNardo broke terms of his 5-year contract when he took a coaching job at LSU in 1994, and awarded the university 1 year's pay, but said the dispute over the remaining 2 years should go to trial. The case continued, and eventually they reached a settlement at $100,000. So, as athletic directors, what can we learn from situations like this? Well, like I said, this whole situation, it was just unprofessional from the beginning. When it come to the contract extension, how they met in the car, after a practice is not the right time or setting to be meeting about something like that. It needs to be in a professional setting, and Coach DiNardo's attorney should have been there, should have been present, because if he was unsure of what he was signing, he only knows that, really, if he was unsure, that's kind of what he argued, is, he shouldn't have signed anything, without being sure what it meant, and all the legalities of what he was signing. But this also looks really bad for the athletic director, Mr. Houlihan, because how he went about this, I'm sure the university was not happy to be having a court case battle over this, and it definitely could have been avoided. So it was a very interesting case. I'm glad I studied it, and thank you very much.